हेलो एंड वेलकम एवरीवन। कैसे हैं आप सब लोग? जल्दी जल्दी से मुझे बताओ, एम आई परफेक्टली विजिबल एंड परफेक्टली ऑडिबल टू यू ऑल? फिर हम सेशन स्टार्ट करेंगे। आज का सेशन है ऑन लीगल रीजनिंग, जहाँ पे विल बी डिस्कसिंग मिसलेनियस लॉज। और मिसलेनियस लॉज जैसे कि बेसिकली कुछ ह्यूमन राइट्स लॉज, या फिर आईपीआर, या फिर सम और द अदर लेबर लॉज। ऑल दीज टॉपिक्स जो हम कवर करते हैं बट इनडायरेक्टली कवर नहीं भी करते हैं, और ये बहुत ज्यादा ट्रेंड में चलते हैं। सपोज कोई भी न्यूज़पेपर में आप खोल के देखोगे तो कुछ ना कुछ एनवायरमेंटल लॉस के बारे में तो पढ़ा ही रहता है। मतलब इनफैक्ट वी कीप ऑन रीडिंग इट ऑन डे टू डे बेसिस। तो yes, all these are the miscellaneous laws, and we will be covering a few questions regarding the same. And tell me first of all that I'm perfectly visible, perfectly audible. Thank you, Kartike. Okay. Ishan, what do you mean by never better? मतलब क्या समझूं मैं इससे? Am I not never perfectly audible and visible to you? Okay. Chal. Let's start with our first question, that is on consumer protection law. फटाफट से passage read करिए. Hi Naini, hi. Thank you Mohit, thank you for the confirmation. Good evening Priyanshi, good evening. जल्दी जल्दी से passage read करो. Then we'll move towards our question. The Consumer Protection Act 2019 replaced its 1986 predecessor and sought to bring consumer rights into the digital age. Among its new features were product liability provisions, mediation cells for speedy resolution, and specific rules for e-commerce entities. A landmark aspect was the creation of the Central Consumer Protection Authority, which can investigate unfair trade practices, recall defective products, and impose penalties for misleading advertisements. One of the CCPA's most notable interventions occurred when it fined a food delivery platform for advertising 50% off on all orders, only to reveal hidden conditions such as a minimum order value or restrictions to select restaurant. Critics argue that such regulatory overreach might discourage companies from experimenting with innovative pricing or marketing. They warn that excessive interference could reduce competitiveness and slow down the growth of India's digital economy. Proponents counter that unchecked advertising gimmicks harm consumer trust, which is crucial for sustaining long term digital commerce. They note that the rising consumer awareness platforms that mislead customers risk both reputational damage and financial penalties. Therefore, the real debate is not whether consumer protection should exist, but how it can balance fairness with the need for innovation in India's rapidly growing e-consumer commerce ecosystem. सबने पढ़ लिया क्वेश्चन? Sorry, the passage. Everybody read the passage? Okay, so the first question, the establishment of the CCPA primarily reflects. What does it primarily reflects? जल्दी जल्दी मुझे आंसर बताओ. What would be the answer? Priyanshi says B. Kartike says B. क्यों होगा बी? उसका भी आंसर दो मुझे फटाफट. Why it would be B? Because the passage basically was emphasizing the consumer rights, investigation of unfair practices, and corrective actions in place. Correct? So, what would be the answer of the second question? फटाफट मुझे उसका भी बताओ. Correct. So, Priyanshi says B again. For the second question, you are saying, Priyanshi, I believe. So, what is the second question? Okay. Which concern is most likely raised by critics of the CCPA's action? What does critics fear? Critics fear overregulation will discourage marketing creativity. Hence, the answer would be B. Or penalties may stifle innovative pricing models is the correct option. Other options are not relevant as such. Moving on with the third and the fourth question. If a student is misled by a limited time, a e-commerce offer, which authorities empower to address these grievances under the 2019 Act? What would be the answer of the third? It's very simple. The Central Consumer Protection Authority (CCPA). The argument that consumer confidence is more valuable than marketing creativity is based on which principle? Rule of law, trust-based regulation for sustainable markets, judicial supremacy in economic regulation, freedom of contract. Correct. The answer would again be B. I think all of the options were B here. जय माता दी टिक करके लगाया होता बी तो सारे आंसर्स बी हो जाते, राइट? तो yeah, the answer is B, the trust-based regulation for sustainable market. Next, in next passage is on environmental law. फटाफट से read करो, giving you 2 minutes to read. India's environmental jurisprudence has grown largely through judicial interpretation rather than legislative initiative. The Supreme Court, in the Vellore Citizen Welfare Forum case 996, reinforced the polluter pays principle, holding that industries causing ecological harm must compensate both the victims and the environment itself. This principle, along with precautionary and sustainable development, has been woven into Indian environmental law. More recently, the National Green Tribunal has played an active role in enforcing accountability. In 2022, the NGT imposes fines on multiple municipal corporations for failing to treat sewage and manage solid waste, calling such lapse a direct violation of citizens' right to a clean environment under Article 21 of the Constitution. Yet, despite these rulings, ground level compliance remains patchy. Plastic pollution clogs river, untreated sewage flows into water bodies, and air pollution exceeds safe levels in most Indian cities. This mismatch between judicial pronouncement and administrative capacity raises an important question. Can environmental justice be achieved merely through court orders? While courts and tribunals can set the standard and impose penalties, effective change ultimately requires robust institutions, scientific planning, and political will. Without systematic administrative reforms, judicial activism risks being seen as a symbolic rather than transformative force. The first question: which principle was highlighted in the Vellore Citizens Welfare Forum case? It is very simple, very simple. Give me the answer. Correct. It's first B for the second passage. Then yes, polluter pays principle we are talking about throughout the whole passage. The passage identifies which main challenge in environmental governance. Correct. It's the gap between judicial directives and ground level enforcement. Moving on, the entity's imposition of fines on municipal corporation is best described as: while tribunal was imposing penalties to hold bodies accountable, the answer should go with A. Correct. The answer would be A, judicial activism enforcing accountability. The author's stances on judicial activism is: the courts cannot achieve justice alone. That means need administrative capacity. So answer would be B, that it is necessary but insufficient without systematic reforms. The answer would be B. Moving on with the labor law, labor reforms in India took a new turn with the enactment of the Code on Wages 2019, which consolidated four separate legislations: the Minimum Wages Act, the Payment of Wages Act, the Payment of Bonus Act, and the Equal Remuneration Act. One significant reform was that the concept of minimum wage was extended universally to all employees, not merely those in certain scheduled industries. This move was aimed at giving legal recognition to the rights of millions of informed and unorganized sector workers. However, the challenges lie in enforcement. India's informal sector accounts for nearly 80% of the workforce, and monitoring compliance across millions of small establishments is logistically difficult. Moreover, the question of fixing a national minimum wage across states has generated debate. While it creates uniformity, it may fail to reflect regional variation in cost of living. States with lower living costs argue that a high central wage floor could make local businesses uncompetitive, while worker representatives insist that a uniform standard ensures fairness. Thus, while the Code on Wages represents a step towards simplifying labor law and protecting workers, its success depends less on legislative drafting and more on effective ground level enforcement and coordination between centers, states, and employers. Moving on, what is the most notable reform brought by the Codes of Wages 2019? What is the most notable reform brought by the Code on Wages 2019 was extending minimum wage to all employers that we are talking about in the passage. What is the biggest practical challenge in implementing the code? The 80% of the workforce is informal, hard to monitor compliance. Yes, then the answer would be B again, dominance of the informal sector. If a domestic worker is an unorganized sector is paid below the notified minimum wage under the code, the answer would be what? The answer would be the worker can legally claim protection as the code explicitly extend protection to all employees. Correct? The author's central concern is in the passages whether minimum wages are justified in principle, the difficulty of enforcing labor protection effectively, the irrelevance of wage laws in modern economies, the monopoly of multinational employers. The answer would be the difficulty of enforcing labor's protection effectively because the focus is less on principle, more on enforcement challenges. Correct. Moving on to the last passage of the day, the rise of a digital economy has brought intellectual property disputes to the forefront. In 2021, the Delhi High Court decided a significant copyright case between a music label and several streaming platforms. The court observed that intellectual property rights are essentially not merely for the financial benefit of creator but also for incentivizing innovations and preserving cultural heritage. At the same time, it stressed that copyright must be balanced against the public right to access knowledge, especially for educational and non commercial purposes. The court clarified that fair use exceptions, such as a teacher using a song or a video clip for classroom teaching, would not amount to infringement. Similarly, non commercial sharing in research or education may be permitted under statutory exceptions. This balanced approach attempts to ensure that copyright law does not become an instrument of monopoly while still recognizing that creator must be rewarded to continue producing original works. The broader policy debate remains unresolved. Strict enforcement may discourage piracy but could restrict access, particularly in developing countries where affordability is a concern. Conversely, weak enforcement may expand access but disincentivize creativity. The challenge, therefore, is to strike a balance between protecting private rights and promoting public welfare. Welfare. Next, why does the court consider intellectual property rights essential? Why would one be? The answer would be B. They protect creators' interest and promote innovations. But why? Give me an why as well. Yes, because the court linked IP to both economics and cultural growth. Second question, which central tension does the passage highlight? Correct. Which central tension does the passage highlight? Correct, Priyanshi. Answer of the second question. Why it would be answer number two, the private rights versus public access, because it was the balance between rewarding creators and ensuring knowledge access towards the same, right? Moving on, the last two questions of the day. If a professor uses copyrighted music in a lecture as a part of teaching, this use would most likely. Correct. It would be permissible under fair use exceptions. The central idea of the passage is that, what is the central idea of the passage? The copyright law must strike a balance between protection and accessibility. That is correct. The author highlights need for balance and not one-sided enforcement. Correct. The answer is A. So that is all from my end for today. I really hope you like the video. Go and subscribe the channel if you haven't subscribed, and follow for more such content. Okay, students, bye bye. Take care.